Hi everyone, thanks for joining us as we come across the criminal trial process. We're going to be looking at the different legal personnel involved. So we start off with the magistrate, who sits all the way up here. If the accused pleads not guilty, then the magistrate is the tribunal of fact and of law, no jury. The magistrate considers the evidence, the rules on admissibility of evidence, and points of law, and oversees the whole conduct of the hearing. At the conclusion of the hearing, the magistrate will either acquit or convict the accused and then proceed to sentencing. If a plea of guilty is entered, the magistrate then proceeds straight to the role of sentencing, and that's going to be discussed right now. Additionally, before I get to that, the magistrate also fulfills a kind of quasi-judicial function if a committal hearing or committal proceeding is held in the local court. Committal proceedings are held if the accused has pleaded not guilty to an indictable, that is a serious criminal charge. These proceedings, presided over by a magistrate, determine whether or not a prima facie case exists. That is, there's sufficient evidence in the prosecution case upon which a jury, properly instructed, could convict. If the magistrate finds, after consideration of the evidence submitted at the committal proceeding, that a prima facie case does exist, then the accused will be required to stand trial at a later date in a superior court. So remember, this is still at the local court. So they will then appear at either a district or Supreme Court, depending on the severity of the alleged crime. Now, the judge still sits in this role up here and appears before defended matters. The judge is the tribunal of law. The judge's role is to oversee, again like a magistrate, the conduct of the trial, rules of admissibility of evidence and points of law, and to instruct the jury on their role and relevant law, including, quite importantly, to instruct the jury at the conclusion of the trial prior to the jury retiring to consider their verdict. So the jury relies on the judge for a lot of things, of what they can and cannot do and can and cannot consider. If a verdict of guilty is returned by the jury, then the judge determines the sentence, usually at a later date. If a plea of guilty is entered by the accused, then the judge proceeds straight to the role of sentencing. Now, the police aren't really included in this diagram, but they do play an incredibly important role because they investigate the alleged crimes and they gather evidence to support the prosecution case. Evidence must be gathered legally, otherwise there is a risk that a judge or magistrate will rule that the evidence is inadmissible because it was gained from an illegal methodology or technique. In summary, for minor matters, police will liaise with witnesses and arrange, probably using a subpoena, for their attendance at court. Police also give evidence in court in support of the prosecution case. Now, the prosecutors act on behalf of the state to prosecute the crime in court. And that's these ones over here. You should remember that this is because a criminal act is one which harms society. Accordingly, prosecutors do not act on behalf of victims in the matter that defense lawyers act on behalf of their client, the accused. Prosecutors are officers of the court and owe a duty to the court to act in an ethical manner. Their role is to present evidence and arguments to the court in support of the prosecution case, both at first instance as well as on appeal, if applicable. It is also part of their role to conduct any relevant negotiations with the defense, such as charge negotiations, which we'll get to in a subsequent video. In the local court, the prosecution of summary matters and less serious indictable matters, which on election are dealt with summarily, is undertaken by the police prosecutor, who is a member of the police force with legal training. Indictable matters are prosecuted by the Director of Public Prosecutions, also known as the DPP. Now, speaking of the DPP, they are independent of the police and the government. The DPP is responsible for the carriage of indictable matters, including committal proceedings in the local court as well as trials in the district and Supreme Courts. A decision has to be made by the state as to whether a prosecution should proceed. In general terms, this will depend upon whether the prosecution can be satisfied that a matter will likely succeed in the courts. Now, you should bear in mind that the state's financial resources are quite limited, and therefore it's neither possible nor desirable that every alleged crime be investigated and prosecuted. It's an issue of resource allocation. Now, public defenders. Now they sit on the other side compared to the DPP. Like prosecutors, defence lawyers, both at the solicitor and the barrister level, are office of the court, and they owe a duty to the court to act in an ethical manner. They need to act in accordance with their client, that is, the accused, needs and instructions, and maintain client confidentiality. Defence lawyers' roles are to present evidence and arguments to the court in support of the defence case, both at the first instance as well as on appeal. Usually solicitors appear primarily in local court proceedings, although barristers can and sometimes do as well. Barristers are actually specialist advocates. They appear for defence in more complex and serious criminal matters in the District Court, Supreme Court, the Court of Criminal Appeal and the High Court. It's also part of their role to conduct any relevant negotiations with the prosecution, again, leading to one of these being charge negotiation. Public defenders operate independently of government. Their role is to represent people who have been granted legal aid in serious criminal matters. Accordingly, they play an important role in ensuring that justice is accessible to people who suffer economic disadvantage.